The 2014 Act, as I said, is 1,400 pages long. The main changes are as follows. Companies must elect to ensure the correct type of company. A new constitution has to be drafted for each and every company. There is an abolition of the ultra vires rule, which is companies acting outside what's defined in their objects. Directors' duties for the first time have been codified, and that's really something I'd like you all to focus on today if you're interested, because that is the most telling and serious matter, and you need to be aware of that. Periods for audit have been extended, and audit exemption has been extended, so more companies can avail of audit exemption, and other companies who have lost their audit exemption for failing or late filing can now make an application to court to extend that period. Director's compliance statement is required for certain companies, and a company, this is probably good for today's group and for people generally, companies can register a connected person on behalf of the company to enter into contracts up to a certain level without being directors, so that when a buyer is dealing with your company, you can appoint and register a person to enter into contracts for you, which removes all doubt as to whether the person has the ability to enter into contracts in the first place. So that's a practical and useful method of verifying that the connected person is the registered person for entering into contracts, and something you might want to make a note of yourselves if you're selling to companies that the person buying off you is the registered and approved person. Company secretary must now have the requisite skill. Heretofore it was the wife, it was one of the people who got the kind of the rump end of the job. It now has to be somebody who has some training, and requisite skills isn't defined, but it is obviously someone with a legal or accounting background, or somebody who has done Chartered Institute, Chartered Legal Secretary's course, or something to that effect. There's a new summary approval procedure. Priorities and securities is very important to know about. That is when a company takes out a charge or borrows money, that the first to register is the first with priority. Heretofore it will be registered against a property. And again, the same applies. The first person registered is the person who has priority over the subsequent, even if the person who's registered subsequently was the person who gave the first loan. So small little housekeeping items, such as registering those charges, is very important to do the day you execute your charge. And charges can be defeated on that basis. New company law offences are very serious, very high, and heretofore small misdemeanours, and what you would have considered misdemeanours, failing to file this or failing to file that, can actually result in the potential for the ODCE to prosecute and fine you. And there is an increase in mandatory electronic filing, which is good, which is the way this bill has been sold, or act has been sold to us, that it's cheaper and it's more efficient. The new company landscape is now, there's 5 main forms of companies in Irish law. There's the traditional limited company, there's the DAC, which is a designated activity company, which, like a manufacturing company, would probably be listed as a DAC. There's the company limited by guarantee. Probably best example of companies limited by guarantees are charities and owner management companies for apartment complexes. And the fourth type is the public limited company, as of old, but the criteria has changed. And then there's the unlimited company, and that's the company that makes the profit and doesn't file their accounts. The big benefit of an unlimited company is a company which is unlimited, means there is unlimited liability, but they don't have to tell the world how much money they're making. And that is actually under scrutiny from Europe at the moment. So what I've handed out on your chairs, or on this side of each of the chairs, is a table, which I'm not going to painstakingly read to, but it's just an example of what was and what is now, and it'll give you a good familiarity with it, and it's worth having a look at that. It's particularly worth noting that the changes that have to be made have to be done within a timeline period. I'm going to read these out to you if you want to take a note of them. So the Act was implemented, or came into effect, on the 1st of June 2015, which affected the Companies Act 2014. And all new companies must take one of the new forms that I've just described to you. All existing private limited companies now operate under Part 16 of the Act, and therefore they are currently treated as designated activity companies until you choose to convert. So right now, if you're a company, a director of a company, you're a DAC. Whether you like it or not, you're a DAC. And then there is a transition period from the 1st of June 2015, and we're well into that now. So there's about 12 months remaining. Actually, it ends the 30th of November 2016, so that's another key date. So if you're going to transfer or to change, as everyone is mandatory to do, rather than having it imposed on you by the Companies Office and a very hybrid interpretation given, you can elect between now and November 2016. So the transition period ends in 30th of November 2016. Within the 15-month period, or the 11 months that are left, a company can convert by ordinary resolution, and that means they don't need an absolute majority at AGM. That's important because shareholders, as you know, sometimes want to find reasons to delay and procrastinate development and forward movement. The 31st of August, by the 31st of August, all existing private limited companies, we have it, all existing private limited companies wishing to become a DAC must have initiated the conversion process by the 31st of August 2016. At the end of the 18-month period, existing private limited companies which have not taken any steps to convert will all automatically be deemed a limited company. So you're a DAC now, and by November you're going to be limited again, unless you decide to take one of the forms. Now, as a guideline as to what form you should take, I recommend, and have recommended in previous talks like this, that really the limited company is for the butcher, baker, candlestick maker type company, because you're now going to have one director, and it's mainly all exempt companies, whereas the DAC is a company with a purpose. Its only purpose is the manufacturing of X or Y. They're not in the business of lending money, they're not in the business of borrowing money, and therefore it sets out to potential investors, to your banks, just what you do, and you're not going to extend beyond that. But if you do decide to extend beyond that, you're no longer going to be found in breach of the ultra vires rule. Director's liability. Okay, company law offences have now been categorised on a sliding scale, each with statutory offence according to specific penalties. So category 1 offences are a fine up to 500,000 or a maximum of 10 years imprisonment. And that is where a party knowingly carries out business with intent to defraud creditors. Category 2 is a fine of up to €50,000 and a maximum of 5 years imprisonment, where any officer enters into an arrangement that breaches the prohibition of loans to directors. The company contravenes the general prohibition on a company limited by shares, issuing shares or debts to the public when it's not authorised to do so. A fine up to €5,000 and or a maximum 6 months imprisonment for non-filing of annual returns and a failure to hold an AGM. Failure by directors to notify of any interest in the companies. A category 4 offences is a fine of up to €5,000, but there will be no liability for imprisonment. And that is a failure to file your accounts on time, or do some of the small housekeeping duties. The power of the ODCE is there to fine you €5,000 or at least seek a prosecution against you for €5,000. So the director's duties here, there's 6, as you can see, 7, as you can see, and these were formerly common law duties that were set out over 100 years of case law and were defined by common law, and they've now been codified. And in many instances that makes it more easier to see, yet harder to comply with. So a director must act in good faith. That's a very wide expression. He must act honestly and responsibly. He must have regard for the interests of members as well as the employees, members being shareholders. He must not use the company property unless approved by the members of the Constitution. Directors must avoid conflicts of interest. Where there are conflicts of interest, they have to be disclosed at board meetings. So if a director had another company and the company was giving services to that company, then it would be for the director to abstain himself or a vote, or at least to make himself aware that contract has been entered into. And that's for private companies. A director must exercise due care and diligence. The director must act in accordance with the company's constitution and exercise those powers for a lawful purpose. A director must not fetter discretion unless permitted by the constitution or unless it's in the company's best interest. So the breach of certain directors' duties can result in the director having to personally indemnify and/or compensate the company. That would be a court order would be made to affect that. The directors must account to the company for any gain or indemnify the company for any loss resulting from a breach of their actions. Shadow directors and de facto directors will consider to be properly appointed directors, and that's a very serious one to watch out for, because with the NAMA legislation that came in, the extension and the definition of shadow directors extends far beyond the wife or anybody connected. So the days of hiding in the shadows literally are gone. And I do think that as this act is interpreted by the courts, because we don't yet know how it's going to be interpreted by the courts, but I think the main thrust of this Companies Law Act 2014 is creditor safety, and it has been drafted with that in mind. So there is an awful lot of nuances that would have been taken from the NAMA legislation. Board of Directors acting under the direction of disqualified directors may be guilty of a Category 2 offence. So that's an interesting one, because it'd be a company where a director has been struck off and has been barred to act as a director, but then has proxy directors in place. That will be found out very quickly, and indeed that is a 5-year prison. Court judgment that is willfully disobeyed by a company may be enforced by attachment against the personal assets of directors. That's quite serious. So in the past, if a company went to war with another company about a certain thing and one of those two companies lost that action, the court made an order against them. The company didn't have the resources to pay or to meet the challenges of that enforced order, then the company would wind up and that would be the end of it, or the company would try and keep surviving and eventually get there. Now it is open to the person who is a successful party in litigation to seek to have that order against the company enforced personally as against the directors, and there's now for the first time a mechanism to do that. And for those of you who have been owed money, that will be a welcome. For those of you who have had to keep the wolf from the door, it won't be so welcome. And indeed, I think that there will be very strong legal arguments when it comes to having that interpreted by the courts. Because it really does lift the veil, and one could argue, well, what is the point in having a limited company status at all in those circumstances? So I think that will be codified by the courts and be interpreted by the courts, and there will be criteria given as to what's reasonable enforcement and what's not. Specific duty under section 330 of the Act to ensure that auditors have all of the relevant information, confirmation that each director has taken all necessary steps to make himself aware of the relevant audit information. So I know that the accountants and Alison welcomes this as an introduction. It puts the onus back on the directors to comply fully with their duties in terms of giving information to the accountants, and not for the accountants to go and make it up or to find it themselves. The Act significantly increases the penalties where a company and its directors contravene the obligation to keep accounting records. The offence for not doing so is elevated to a Category 1 offence, which you recall is 10-year imprisonment. Directors may be criminally liable for untrue statements and exposed to a maximum penalty of 50,000. Directors of insolvent or liquidated companies at a higher risk of disqualification proceedings from now on, or from June last year onwards. So everybody's probably feeling really encouraged by this new Act. Directors' compliance statements. Alison's going to do that now.
Good afternoon, everybody. So the director's compliance statement is something that we're going to see more of. It is an obligation for companies with a turnover that exceeds 25 million and a balance sheet that exceeds 12.5. However, you'll see people with good governance, good boards, you'll see more and more compliance statements in the financial statements. So what is the compliance statement? You have to acknowledge that you're in the director's report that you're responsible for securing the company's compliance with its relevant obligations. So again, the board needs to know what are the relevant obligations. The directors must confirm that the company has a policy on compliance, and that will have to be produced if required. They must also confirm the arrangements in place to ensure how the compliance is going to take part. First one, this is somebody at my knees at a presentation, so sorry about that. And they must confirm a review during the financial year has been done, and that this structure and arrangements are in place to ensure that they are compliant with the statement. the effect on the financial statements. So, like Mark said, a lot of the onus is back on from the auditor to the directors. So there is no longer a requirement for the directors to sign the profit and loss account, and this is just recognising that the balance sheet is the most important part of the financial statements, and everything is going to filter through profit and loss one way or another. So there's no longer a requirement to sign the profit and loss. However, on the balance sheet, you used to have two places, director, and there'd be a little squiggle, and nobody would know who signed it. Now you have to have the title name printed, and again, it's somebody is taking responsibility for that. If an item is material, it must have an accounting policy. So what's material? Material is different in everyone's circumstances, and you have to look at your company and your thresholds. An accounting policy, the directors are required to set the accounting policies. However, they may not know what they are because they may not be accountants. So it's very important to have your trusted advisors and have them work with you, and just be aware that that is the case. The directors must state now as well that the accounts give a true and fair view. So again, that used to be the auditor's job to say that the accounts give a true and fair view. That's now the director's duty. So again, you have to also make sure that you make all the relevant information available, and it's not in financial statements as of the 30th of June. However, it will be from the 30th of December 15 year end. There will have to be a statement in the director's report now as well, saying that you've given all the relevant audit information. Failure to comply with the changes on the financial statements is a category 2 offence. One of the big things that is causing a lot of grief for our directors is that on the abridged financial statements now that go into CRO, the staff note and wages and directors' remuneration and all payments made are shown on the financial statements. It's shown on one global note as staff, and then it's shown on a separate one showing the directors. So again, it depends on the size of your company and what will get disclosed, how many directors, but it's going to be very easy for your competitors, your customers and other people to see what the directors are being paid, and your staff. So a lot of people have issue with it, but it's the law now. In respect of every item on the profit and loss and balance sheet, if you have a note for one of them, you now have a comparative. The big change where we see this is in the fixed assets note, where you always had the current year full note and you show the net value of the prior year. Now you'll have to show a full note. If you enter into an unsecured informal arrangement with the company by way of director's loan, and you don't set an interest rate and you don't set a charge, as Mark said, you'll be down the line in the creditors. And also, if you take a loan from the company and there's no formal arrangement, there will be deemed interest given of attached with a 5%. Once again, the auditor is no longer required to give an opinion whether proper books of account have been kept. Again, this is now something on the B1 and also on the financial statements that the directors must state that the proper books of account have been kept. Now, as Mark said, with the Companies Act there has been a scope for extending the audit exemption. So before, with these thresholds here, you had to meet 3 of 3 to go audit exempt. It's now that you have to meet 2 of 3, which is bringing more small companies into it. If it still didn't get rid of, so if you're late 1 year, you automatically have to have an audit the next year. That rule still applies, unless your company is the only one that can change it is a dormant company, and you must elect before the year end if you'd like to go audit exempt for the current year. So what we have to look out for audit exempt, you have to be aware that 90% of the members have to agree. So if you've got a shareholder 40-40-20 and 20% says no, I do want an audit, and the other 2 husband and wife say we'll go audit exempt, but only 10% of your members have to disagree, and they can request that an audit is taken into place. So you have to give that opportunity for people to agree and pass it. And then if as Mark said earlier, if you were late last year and that automatically made you audit, you can make an application to the district court to get that removed to be audit exempt for the current year, but then you have to weigh up how much is the application going to cost versus how much is the audit and how many years you have to do. So that's something that, you know, you just weigh up the costs and the implications and see what's best. In relation to CLGs, companies limited by guarantee, they are now able to avail of the audit exemption also. However, if they are in the not-for-profit sector, the CRA won't allow them to have them go audit exempt, and that's if they have turnover of 100,000 plus. So the company law has extended it, but other regulations have to be bear in mind as well. So what do you have to bear in mind? You have to bear in mind 10% of your shareholders, or if it's a CLG, it could be just one member. And then, like that, dormant companies cannot retrospectively avail of it. So if they want to avail of it for the 2016 year, an application would have to be made within 16. So 2015 is gone. There's no applications that can be made. In relation to the strike-off and restoration process, there's now a statutory recognition of the voluntary strike-off process. This is for the first time. The members must pass a special resolution for the strike-off to be effective. The involuntary strike-off process hasn't really changed. The ODCE have the power to require directors being struck off to produce a statement of affairs. The time frame has been extended from 12 months to 15 months, and a company that previously was struck off the register who could have up to 20 years to restore itself has been, if its investment company has been restricted to 2 years now. So I'll just hand you back over to Mark and a quick summary of what we've gone through there.
Okay, I hope you all are still with us. As I said, it's a fly through of 1,600 pages, so don't expect to be fully educated as to the Companies Act 2014 at this seminar, but naturally you're going to say you're free to come and talk to us at any stage, and our contact details are around the room. But you know, I'd be happy to hear from anybody who's got certain queries, and certainly on a pro bono basis, just in terms of interpreting or understanding it, and thereafter to develop a relationship. There's a summary here now of what I've already said, so again I'm not going to read that to you. I think that the best advice I could give is for you to encourage your companies and or directors to convert as soon as possible. I think probably most of you probably have at this stage, because it's just good corporate governance, and banks like to see good corporate governance and insist on it.